Hello, everyone. Good evening to you all. I am super excited once again to be here facilitating our second class in government. I remember last week we talked about the definition of government as according to the three parameters. We looked at the importance, we looked at the element, and we made an assessment after the class. So today we're going to continue from where we stopped. We are, however, going to start looking at the principles of government. We're not going to rush, we're going to take our time so we can have a good grasp and understanding of our subject matter. So today we're going to talk about the rule of law. I am very sure you've all heard of the term rule of law. It's a basic tenet and principle of any government. All right, so the rule of law is how citizens are governed by the rule of law and not by power of others. The law is a legal proposition that treats everyone equally in the same situation. Law is needed both for individuals as part of the state, as people who have rights and obligations as well. Theoretically and practically, law as a discipline should have an analysis model and be able to solve various problems, because this is the view that the law has flexibility in regulating our lives. So I must say that for every single state that has a government, there has to be the rule of law, not only to guide the affairs of the state, but also to safeguard the interests of the masses. So it's a two-way thing. The rule of law ensures that the state is able to run its affairs smoothly, as well as the citizens being able to conduct themselves in a manner that will not affect the smooth running of the state. So that's what the rule of law is all about. And it is very important to note that the rule of law did not just exist or appear, it has evolved over time. And we have various scholars in the past who have come to give their own opinion as to why there is or there should be the rule of law. Some of the scholars will include Aristotle, John Locke, Baron de Montesquieu, or Montesquieu as some people would say. I will just shed some light on their views about the rule of law. Aristotle, one of the greatest political philosopher that ever existed, Aristotle defined man as zoon political, a political animal, because man cannot do without politics. Like I said in the first class, it is possible for you not to be interested in politics. However, it is impossible for you not to be affected by politics. So man is a political animal, voluntarily or involuntarily. That has been Aristotle's stance. So as regards the rule of law, Aristotle sought to answer the questions that what should really be the priority of the states? Should it be that men should govern the affairs of the state, or laws should be made to guide our affairs? Because he said, if you look at the court of law, if you leave men to just use their intuition in addressing issues at the court of law, they can bring in biases, they can bring in moralities, and all these. They may not even have a very good grasp of the situation before passing judgment. But when the law is in place, the law is empirical, they can subject their views to the law. The laws will help reduce biases, personal sentiments, and moralities. It will help reduce them to the minimum. So Aristotle opined that the rule of law should be advocated because it helps to protect democracy or democratic government. So going over to John Locke was also a political philosopher, and he also said that the rule of law is necessary because he looked at it from an agrarian society whereby people have properties, rather. You understand? He said people should be given the free hand to own properties. So for you to be given the free hand to own properties, there has to be law guiding the acquisition of properties and law limiting people from unnecessarily exploiting people and taking their properties. Hence, there is a place for the need of rule of law. Then lastly, we go over to Baron de Montesquieu. Of course, we all know that it's a popular name because He emphasized the rule of law, especially in a principle called separation of powers. You understand? He opined that the judiciary should be separated in terms of its functionalities and there should be undue interference. So, for the judiciary to function well, there has to be laws that it will bring about in making sure that it's able to function maximally without undue interference. So that's just been a tip of the history of the evolution of the rule of law. Different scholars have come to posit different meanings or different situational meanings to what the rule of law is, but they all have a central idea that the rule of law should mean that there should be laws guiding the affairs of the state on one hand, as well as private individuals on the other hand. So there will not be a clash or conflict of activities and interests. I hope you got the explanation. Now, it is very important to note that every citizen is a subject of the law of the state, which is carried out in a general court. Rights are not based on the constitutional outline statement, but the actual decision of the court. That's where of course, you can defend yourself or you can get tried according to the law. It's the law court, and that's why Baron de Montesquieu opined that the judiciary is very important in ensuring that there is rule of law, because that's the only place you can really that can really guarantee the rule of law. So I'm going to talk about critically 5 principles that defines the rule of law, or I'll just generally talk about some principles. Then you pick the ones you want to. The principle of legality. For every society, a society that has a government, the government in modern times has to be legitimate, has to be legal, it has to be acceptable, it has to be accepted by the people. Now, for you to say the rule of law is a rule or it's a law, it has to be legally accepted. It has to be legally documented. Do you understand? It has to be legal. For instance, if you're going to defend or you're going to sue a person in a law court for the infringement of your right or for different things, you have to be able to prove it in the books that there is a law in this regard to protect you. Do you understand? I'm not talking about unwritten constitution. I'm talking about the rule of law. For there to be law or for there to be rule of law, the laws have to be legal. They have to follow the processes of becoming a law, which ultimately will result in those laws being in a defined set of documents. So that gives it its legality. All right. So the next one is the protection of human rights. For any law or for we to say that the rule of law exists in any country or any government, that government has to exist to protect human rights. Generally, if any society or any government is devoid of human rights, then we say that government, it's not even observing the rule of law, which makes it quite illegal. A lot of times we look at the military regimes. There are lots of infringements of human rights when it comes to military regimes. They tell you when to sit at home, when to go out. Sometimes they tell you not to talk to the press. They bar you from traveling. They take away so many rights from you. So most military regimes do not have rule of the law. Do you understand? So most times it makes them illegitimate government, and that's why there have been clamor for them to do away with military forms of government. And that's why, if you look at it generally now, we rarely have military forms of government, because those forms of government are not legitimate. The rule of law is absent. Once the rule of law is absent, there cannot be the protection of fundamental human rights. Okay, for we to say that the rule of law is what it is, there has to be the monopoly of the government coercion to ensure law enforcement. I talked about this in the other class. The government has the sole monopoly of the use of coercion or force in making sure that the will of the state is carried out. For there to be a law, that means there has to be an enforcement. It's just like saying, they say, don't urinate here by law. That means if those laws have been passed and deliberated upon, it became from a bill for we are going to get to organs of government, how a bill becomes a law and all that. So, for instance, if there is a law that prohibits people from passing urine or defecating in an open place, which is in a document, there has to be a form of enforcement that will make people not to want to do that. So the government has the monopoly of the use of coercive force in ensuring that people don't do that, either by using the military apparatus or using security agencies to make sure that those laws are conformed with. It is only the duty of the government to have such monopoly. So for any government to say there is the existence of the rule of law, there has to be the presence of the monopoly of the use of coercive power or coercive force. Because for every law, there has to be a form of enforcement or implementation. Without that, such law is not valid, or such law will not hold water. I guess you're following me. The next one will be, as a principle, there has to be an oversight by an independent judge in matters of the government implementing and enforcing the rule of law. Now, this is also a very important element or feature of the rule of law. Even the government is not above the law. And that's why in the definition I gave earlier, I said the rule of law are sets of laws that guides the affairs of the state on one hand, as well as the citizens on the other hand. So the citizen is not above the law. The government itself is not above the law. So there are times whereby the government will flout the law and the government will have to be brought to book. So that gives room for the independence of the judiciary, and that's why Baron de Montesquieu was saying vehemently that for there to be rule of law, it's actually the most important part of rule of law as an element is the independence of the judiciary, because the government is not greater than the law, in as much as the government implements the law. Human beings as well, which are the citizenry, are not also greater than the law. So the judiciary is always the most important body when it comes to the rule of law and its implementation. Because when you have cases against the government, you take it to the judiciary. And when the government has cases against citizens, they will take you to the judicial arm of government. And by that, the rule of law is enforced, because the government cannot take laws into its own hands, as well as the citizens. So I hope you all got that. Of course, we go over to the importance of the rule of law. Why do we need rule of law? Or what is its relevance in modern times? Okay, rule of law helps to check the abuse of powers by authorities. There is a popular quote by Lord Acton in 1921. It says, "Power tends to corrupt, and absolute power tends to corrupt absolutely." So, for instance, as a layman without power, it is going to be very normal for you to go about your daily lives without threatening people or trying to flex your muscles. But when you give such man power, that's when the true character will come to bear. Are you following me? So, power tends to corrupt, and absolute power tends to corrupt absolutely. So having this at the back of our minds, it is important to note that there are times whereby those in powers will abuse power. So the rule of law tends to help to place a check on these persons in government. And that's why if there is an infringement of your right by the government or its officials, you have the right to contest such in the law court. You go and file a suit against them, and if chances are that you're right and you're able to defend your case well, you win, and whoever it is that is the culprit is brought to book. So the government, even when the government comes and take away your properties or demolish your house, you can take the government to court if you feel that it's an unnecessary abuse of power, and at the end of the day you can be compensated for what. That's what we call the rule of law. So the rule of law helps to check unnecessary abuse of powers by the relevant authorities. That's one. It empowers individuals with the rights which cannot be easily taken away, like we have said as a fundamental element. When we talk about rule of law, that means we're talking about that there is respect for human rights, the rights to basic things in life. Nobody can just come and box you in one corner, just like the military era, whereby even your life is not your life. They can tell you, they can conscript you into the army, and there's nothing you're going to do, anybody's going to do about it. But now there has to be consent and a lot of processes to follow. That's what the rule of law guarantees. It treats everyone equally without discrimination, whether you are a billionaire or you're a millionaire or a thousandaire, or wherever it is you are, whether you're from Edo State or you're from Kaduna or you're from Ogun State or anywhere you are you're all equal before the law. The law doesn't discriminate, and that's the beauty of the rule of law. Its supremacy ensures that no one can claim to be above the law. That's very awesome. Imagine even our president cannot be above the law. Of course, but sometimes we see that even governments flout the law and they go against the law. But ideally, government is not above the law. No government official is above the law. The same way with the citizens, no one can claim to be above the law. It ensures adherence of principles of natural justice, like giving reasonable opportunity and not making impartial decisions. Fair hearing, that's what it is. For instance, if they are convicted of murder, instead of just taking you to a firing squad or doing a jungle justice for you, the rule of law says you have the right to fair hearing. You have to stand before a judge and have a lawyer or group of lawyers come defend your case or prove your innocence otherwise. So it gives room for the principles of natural justice by giving reasonable opportunity for you to defend yourself, which is awesome. Now, I've been able to define rule of law, give the historical background to the rule of law. I've also briefly explained the elements of the rule of law, and as well as its importance. But it's important to know that there are limitations to the rule of law, particularly in Nigeria. First will be delegated legislation. Top government officials, especially in the executive branch, are granted some discretionary powers, and this allows them to perform their duties efficiently. However, due to the fact that these human beings are selfish and love power, this opens up the opportunity for them to use this privilege against citizens. It is most times referred to as the abuse of power. A government official can make lawful sanctions that abuse the rights of an individual or society when they are administered. So that's one demerit of the rule of law, like a limitation, because there is what we call delegated legislation. The executive arm of government actually have the right to delegate powers to individuals to carry on an assignment. But sometimes in the discharge of these duties, these individuals abuse those powers and in the process unleash mayhem on the general citizenry, abusing their rights, all in the name of having delegated powers to perform some function. So that can be a limitation to the rule of law, which most times is not avoidable. An executive member cannot be everywhere, so he has to delegate powers to different units to effectively sort out issues. Another one is special privileges. This also is another limitation to the rule of law. Some people enjoy special privileges and exceptions under the rule of law in Nigeria, for instance. These people have immunity against the law. They include the president, vice president, governors, members of House of Assembly, and even some other top government officials. Also, a judge is immune from the law while presiding over a court session. This allows them to go about their duties without favor or fear. Now, on the positive side, imagine when everyone is suing the governor or suing the president, it makes the president or the governor very distracted. So there is always an immunity clause with all these government office holders, such that you cannot try them while they're in office, so that you don't distract them unnecessarily, because that also can breed further problems. So there are special privileges given to these persons. They are practically not subjected to being trialed while in office, so which is a limitation to the rule of law. You can't possibly try a governor while he's seated. That's why you see most times EFCC will only come after a person after he has left the office. But while in office, it is very rare for you to be able to try such government holder. So that's what we call special privileges, which is also a constraint to the rule of law. If we're saying no one is above the law, then why can't you try some people as a Wendy? Why do you have to wait until when they are off the government position? So this is a limitation to the rule of law in Nigeria specifically. We also have what we call diplomatic immunity. Here, diplomats and ambassadors have immunity against the rule of law in the country they are serving. They are above the legislation of that country. For example, an envoy from the United Kingdom cannot be charged or tried in Nigeria. They have to be sent back to their country. So, for instance, if I am appointed as an ambassador of Nigeria to Canada, If I commit an offense as a diplomat of my country or an ambassador of my country to Canada, if I commit an offense in Canadian authorities rather cannot try me. They have to send me back to my country, which is a limitation to the rule of law in Canada. I hope you're getting that. State of emergency and war is another limitation to the rule of law. In cases of conflict or situations which require the government to declare a state of emergency, the government enforces discretionary powers, and when the government exercises these powers, it denies people of their constitutional rights. People are restricted from carrying out their normal day-to-day activities and forced against their wish. Okay, so I know we can all relate with this. It's a typical example is the COVID-19 pandemic. When we started recording cases in Nigeria, the government had to deploy discretionary powers, and the discretionary powers had to make a lot of us sit at home for quite a long time, and it affected our freedom of movement and a lot of other rights, right to work, right to do a lot of things. And this is a limitation to the rule of law. So in times of emergencies or war, laws cannot really take place because the government of the day will have to make use of discretionary powers. That's why they call it a state of emergency. Once we enter a state of emergency or war times, law is always the first thing that is suspended, because everything that has to be done has to be discretionary. For instance, if Nigeria enters a full-blown war, like for instance in the Civil War where we were having a state of emergency, a lot of people were conscripted into the army with or without their own concepts. They'll conscript all the young able-bodied men and put them in the army against their own wish because we're in a state of emergency. So that's another constraint to the rule of law. State of emergencies and war times always creates an impediment for the law to take its course. Also, illiteracy, poverty, and ignorance sometimes contribute to the limitation of the use of the rule of law. The level of poverty and illiteracy in Nigeria is also a limitation to the rule of law. A lot of people live in ignorance of their constitutional rights, which makes it easy for people to infringe on them. That's why in more sane societies, they will tell you, I'm going to call my lawyer, because those ones already know what the law is all about. So it's difficult for anyone to come and bamboozle them or bubble them with one thing or the other. But here, when they tell you one small thing, you start panicking. You want to start bribing or start begging. Whereas you don't even know what the law says about that issue at hand. So illiteracy, poverty, and ignorance also affects the full implementation of the rule of law. Because if you don't know there is a law protecting you regarding a certain thing, and you want to be punished for it, and you don't know that you are actually not supposed to be punished, what will you do? Either you bribe them, or you beg them, or you surrender. So it affects also the implementation of the rule of law. So I hope you've been able to get some few points from the class that we have had today. So there has also been an eternal debate, the rule of law and rule by law. Okay, of course, rule of law means that no one is above the law. The government, the citizenry, everyone is subjected to the tenets of the law. All right, but when you say rule by law is always mostly an instrument used for political businesses, you understand, whereby the government of the days use those laws to further their own personal interests. Okay, so that's the difference. Rule of law is when no one is above the law. Everyone has to submit itself to the laws of the land. But the rule by law means that you use the law as a political tool to further your own personal wish or agenda. So your class exercise will be that how is the law? You explain 3 limitations to the rule of law. That's the first question. Explain 3 limitations to the rule of law. And 2, how is the rule of law different from rule by law? So you send them to my DM. Thank you so much.